Appeals Division 1 is now in session.
Please be seated. I have to get my eyes on so I can see. We're here today in our case 1CA CV 150487. It's Yellow Kettle versus Sedona. Each side will have 20 minutes for argument. Appellant, if you want to reserve any time for rebuttal, you're free to do so. But whether you do and the extent that you do is up to you. We are recording the argument on YouTube. So in a few days, if you want to see how you did, you can just pull up our channel on YouTube. Because we're recording the argument, when you approach the podium, please state your name and your client so that we can keep everything straight. We've read the briefs. We've conferenced the case, so we're familiar with the facts of the law. So when you come up to argue, just launch right into your argument. Counsel, you may begin.
Good afternoon, Your Honors. Eric Frazier on behalf of Yellow Jacket Drilling Services. Karen Palasek is with me at counsel table. I have just a preliminary question for the panel, which is, do you have a preference for how to address the issues on appeal versus cross-appeal? I'm happy to address both sets of issues in my primary argument, but if you have a different preference, of course, I'll proceed however you'd like.
We haven't really thought about it, but go ahead and start with your appeal argument.
Okay. I'd like to say 5 minutes for rebuttal if I can. Your Honors, this case cannot be resolved on the pleadings, and here's why. Notice of claim compliance is an affirmative defense. So Yellow Jacket had no reason to think that the notice of claim compliance would be an issue because Sedona had already treated the claim as a litigation claim and had committed to resolving the dispute. Moreover, the law is settled that notice of claim compliance is subject to the equitable doctrines of waiver and estoppel. As a result, Yellow Jacket did not need to preemptively rebut an affirmative defense in the complaint, especially one subject to waiver and estoppel. As a result, the original complaint stated a claim and never should have been dismissed, even though it was silent on notice of claim compliance. After that, the Superior Court raised a requirement to plead notice of claim compliance in the complaint. But at that point, Sedona had not raised the issue of service on the correct party. As a result, again, Yellow Jacket did not need to preemptively rebut that defense in a complaint in order for the complaint to state a claim. If the Superior Court imposes an additional pleading requirement of preemptively rebutting what amounts to an affirmative defense, then Yellow Jacket should have an opportunity to amend the complaint to satisfy that requirement.
Counsel, the project was completed in December of 2013, and Sedona told Yellow Jacket on January 21st, 2014, that it wouldn't, wouldn't pay the full amount. Was there still time at that point for Yellow Jacket to file a notice of claim and a complaint?
In January 2014?
Yes.
Yes, I believe there still would have been time, but at that...
And why didn't Yellow Jacket do that then?
Because at that point, Sedona had already said, both in October 2013 and in November 2013, we've received your claim, we will evaluate it, we'll review the notice of claim. And so at that point, Sedona had essentially told Yellow Jacket, we're all good here. At that point, there was no reason to to think that there was any problem with the notice of claim that had already been sent to Sedona. And we recognize that we sent it to the wrong party, or the wrong entity at Sedona. But because we had already served a notice of claim, and Sedona had both acknowledged receipt and committed to evaluating that notice of claim, there was no reason to think that any further action was required. That gets at the heart of waiver and estoppel.
So when do you think your claim accrued?
The accrual date is subject to some uncertainty, but there's no doubt that we served a valid notice of claim both before and after the accrual date.
Okay, I'm not sure that answered my question. Are you willing to tell me when you think it accrued?
I don't think that the accrual date is necessarily an issue in the appeal, so we haven't set a firm accrual date on the claim.
Okay.
But the bottom line is that the city cannot treat a notice of claim as a litigation claim, tell the claimant that it will consider arbitration, and then turn around and say, sorry, in fact, we didn't get a valid claim.
Well, who told Yellow Jacket?
Outside counsel for Sedona.
And are they authorized to speak for the city for issues of notices of claim?
At this stage, where we're on a motion to dismiss, I think we have to assume that outside counsel is an agent of the city. Outside counsel represented that these were communications coming from the city. And the letter specifically said, the city has authorized me to tell you the following things. That we've received the notice of claim, we're going to consider it. The letter referenced stipulating to arbitration. So I think at this stage, we have to assume that outside counsel is permitted and have the authority to speak on behalf of the city. Of course, it's the same outside counsel who's arguing before you today. If that becomes a fact issue, then that's something perhaps the parties could take discovery on. But on a motion to dismiss, I think we can assume that outside counsel had the authority to speak on behalf of the city. So this isn't a case where you have a low-level city administrator, for example, speaking on behalf of the city, where there's some question about whether that individual could, in fact, bind the city. Here we have outside counsel hired by the city, engaged for this matter, where the letter specifically says Yellow Jacket Drilling Services, V. City of Sedona. I mean, that is clearly contemplating litigation. That's the exact same caption that appears on this case now on appeal. So the doctrines of waiver and estoppel guard against this kind of game of gotcha, where a government entity lulls a claimant into thinking that there's no issue of notice of claim compliance. This court need only apply settled law to reach that conclusion. That's the Young case in Arizona. That's the Teresta case out of New York. Here we have 8 factors, all of which demonstrate that we can establish estoppel, or at least that we can plead estoppel. The city, again, acknowledged receipt. They said notice of claim received in all capitals. The city expressly committed to reviewing the notice of claim. This is a quote. The city said, we are in receipt of and will review the notice of claim. Again, engaged outside counsel, treated the matter as a legal dispute with the same case caption as we have today. Extensive communications about the claim, meetings, letters, phone calls. The city, in fact, made a settlement offer and then considered a counteroffer. It affirmatively waived the mediation procedures in the notice of claim rules and then discussed stipulating to arbitration. At a minimum, Yellow Jacket should have been given leave to amend to plead these facts in a complaint, to try to establish that it can at least overcome and rebut the notice of claim defense, which again is an affirmative defense that we had no responsibility to preemptively rebut in the complaint. This case cannot be resolved on a motion to dismiss. The facts here, I think, would preclude even summary judgment, but let alone a motion to dismiss where the court accepts the facts as true and draws reasonable inferences in favor of Yellow Jacket. The ruling of the Superior Court did not even address or mention waiver or estoppel. We submit that that ruling should be reversed. On the cross appeal on attorney's fees, again, if you reverse the dismissal, then the cross appeal is moot in its entirety. But otherwise, Rule 54G, as interpreted by the Balestrieri case, requires that the request for fees be made at the first available opportunity, in an opening motion to dismiss, not in the reply. I'd like to draw the court's attention to a recent amendment to Rule 54G that is part of the new rule set that just took effect about a week ago. The new rule confirms this interpretation of Rule 54G. The new rule expressly requires fee request to be made in an opening Rule 12 motion. And the comment to that amendment, the new rule contains a comment. It's one of the very few rules in the new rule set where the Supreme Court adopted and approved a comment to the rule. It says that the new rule codifies the holding of Balestrieri. So even though the amended rule, of course, did not apply to this case because it just took effect a week ago, the new language and the comment confirm how to interpret the old rule in Balestrieri, because, again, the new rule was meant to codify that holding. Your Honors, in light of the fact issues concerning waiver and estoppel, and because a party need not preemptively rebut an affirmative defense in the complaint, we ask that you reverse and remand.
Thank you, counsel.
May it please the Court, good afternoon. Stephen Richmond on behalf of the City of Sedona. With me at council table is my colleague, Brad Burns. There's a fundamental misconception here. There was no compliance, period, none, with 82101. The statute mandates service of a notice of claim on the city clerk. That did not occur here. So any statement to the contrary that, oh, well, we did serve a notice of claim is wrong. They did not serve a notice of claim. The issue about whether the trial court should ever consider waiver or estoppel doesn't even arise unless this court finds, I respectfully suggest, that the trial court abused its discretion in failing to grant leave to amend in the face of no requests for leave to amend, number one, and in the face that the fact that the judge had already allowed leave to amend after Sedona filed a motion to dismiss the original complaint.
Counsel, what's the purpose of a notice of claim?
To provide notice that the public entity, the political subdivision, may be subject to litigation so that it can be evaluated and settled.
Yeah, that seems to have happened here, even though no notice was filed.
Well, it didn't happen here, Your Honor, for the very simple reason that when terms are thrown around like the city and Sedona, that does not represent anybody except for the city clerk. That is the chief officer to whom these notices are required by statute and the Arizona Rules of Procedure to go to. Sending it to anybody else doesn't suffice. This court, as well as the Arizona Supreme Court, has made the law clear. This is not a new concept. That actual notice and substantial compliance with the 82101 are not sufficient. We have several examples of those cases. Deer Valley versus Hauser, the Arizona Supreme Court, excuse me, yeah, that's one, where it said that the compliance with the statute is not difficult, and that where there was a reference to approximate damages and maybe damages wasn't sufficient enough. In Falcon versus Maricopa County Superior Court, delivering a notice to one of the boards of supervisors wasn't sufficient to satisfy the notice of claim. In the Martineau versus Maricopa County Court, delivery to the notice to the risk management office of the county attorney wasn't sufficient enough. So Your Honor, although we might say actual notice and substantial compliance are good enough, the law in Arizona tells us crystal clear it is not. All this notice ever got to was the appropriate person to address contract claims, Ms. Holland, the associate city engineer. The fact that it then went up the contract claim process to the city engineer, who, not unsurprisingly, sought the advice of the city attorney, and the city attorney, because it was a specialized area of law, sought the advice of outside counsel, does not substitute for proper service on the city clerk. I answer your question, Judge Howe?
Yes, I did.
Okay, thank you. So unless this court can find an abuse of discretion by the trial court and not allowing leave to amend that wasn't asked for, waiver and estoppel isn't even in the record. It shouldn't even be considered. Now, here's why this court cannot do that, in our humble opinion. The Blumenthal v. Tietz case that we cited to you was a situation in which a shareholder derivatives action was filed. That, under Rule 23.1, requires notice to the company to take action before we file derivative action. That action, that notice apparently wasn't given, or there was an allegation in a motion that wasn't given properly. In a response to the motion, the party asked for leave to amend the complaint. The court said, and Judge Johnson said, that's not sufficient. Here there's a process under Rule 15A for seeking leave to amend. That process wasn't filed here. So what we look at here, then, so there is no abuse of discretion. This complaint should not have been amended. It was never requested. It's basically, let us amend on appeal. I want to point out one inaccuracy I believe that Mr. Frazier made. When the original complaint was filed, the city filed a motion to dismiss and said there was a failure to comply with 82101. Yellow Jacket was on notice of that, sought leave to amend, that was granted, filed the amended complaint. In terms of the question you asked, Judge Winthrop, we believe, and we're not challenging this on appeal, nor has the appellant, more importantly, that the cause of action accrued on January 24th, 2014, when the city said, we're not paying you any more money on your change order requests, and we're withholding retention. Okay? So in the face of that, what the trial court found, we take a look at the first amended complaint. What does the first amended complaint, which is what the trial court dealt with, what does it tell us? It tells us, critically, in paragraphs 14, that the city didn't pay, that Roxanne Holland, the associate city engineer of the city of Sedona, and the representative for purposes of contract authorization for change orders and claims, sent an email to Yellow Jacket after they submitted their invoice on January 14, 2014. This is the one where they held the retention. The allegations of the complaint recognize that this is a person who's a contract authorization person, the person they're dealing with on an ongoing basis. Paragraph 19. The allegation is Yellow Jacket has made claims against the city that include outstanding unpaid amount not only for the $6,450 that was not paid for liquidated damages, but Yellow Jacket has made a claim to the city for differing site condition claim after multiple notices of potential claim. And then it references that an initial notice of claim dated October 24 was addressed to Roxanne Holland, associate engineer, consistent with specification section 52B. That's the contract dispute resolution process. You don't need to get to waiver and estoppel because it's not in the record. But even if you were to get there, the only case that is an Arizona case that deals with pre-litigation conduct that amounts to waiver of a notice of claim is the Young case. Every other case that the court has addressed, and the Supreme Court in the City of Phoenix versus Fields, this court in Jones versus Cochise County, this court in La Paz versus Yakima County, this court in Arpaio versus Maricopa County, I believe that was authored by you, Judge Winthrop, all involve situations, except for the Arpaio case, just talk about a situation, which there was active litigation and the notice of claim defense wasn't raised in a timely manner. Active litigation after the notice of claim defense was available. Even under the appellant's version of the world, the letter I wrote in June still left them under the cause of accrual date that's not been challenged that the trial court found in January with some 40 days to file a proper notice of claim. So that's one distinction from Young. All but Young involve lots of litigation for years and years, participation in discovery, and then raising the issue of the failure to comply notice of claim. That's not what happened here. The other thing that Young is distinct is Young involved personal injury. Here we have a case in which there's a contract with a dispute resolution process. It would be a far cry for the court to say that the city properly addressing contract claims at the contract level, and even if it chooses to get counsel to help it, is somehow thereby waiving a completely separate mandatory statutory notice of claim process. A process, Your Honors, the actual notice doesn't suffice, and substantial compliance doesn't suffice. So that's not, Young is distinguishable for that reason. The other reason Young is distinguishable is in Young it appears that the injury occurred 8 months before the so-called acts that the Court of Appeals mentioned were a possible waiver of the notice of claim statute. And those acts occurred, the acts that the court says without real analysis is, no, claims adjuster opened a file and talked to the plaintiff. That happened 8 months. So it was when the notice of defense, the notice of claim defense was available. Here, the notice of claim defense wasn't available till the earliest after July of 2014. And as soon as it was available, when the original complaint was filed, SEDONA asserted it. When the First Amendment complaint was filed, SEDONA asserted it. The last thing I want to address, subject to any questions that your honors have, is when you look, even if you look at the letters that are attached to the First Amendment complaint, that the appellant claims comply with the notice of claim statute, which of course they don't because they're not sent to the chief officer. The city clerk is supposed to get it. And so there's no authorization but for the city clerk to handle these. Nobody else is authorized to handle these. But when you look at those letters, the only one I would ask you to focus on to show you that waiver does not apply is a letter dated, it's Exhibit 10 to the complaint, which of course is Index of Record 9, and it's a letter dated February 28th, and it's written on the stationery of Yellow Jacket, and it's addressed again to Ms. Holland. So appellant would like this court to believe that in October of 2013 there was a seismic shift, and we got past this contract level, and we went to this other level with this claim. But months later in February, they're sending another letter to the associate city engineer asking for more money under the contract. So it cannot be waiver. With respect to estoppel, Mr. Frazier didn't mention estoppel in any detail, and that's because as hard as waiver is to find that a political subdivision has intentionally waived its rights, which certainly didn't occur here when it's complying with a contractual procedure, estoppel is even more difficult. Estoppel is frowned upon. It needs a rare case. It needs substantial justification. And here the city's acts were at least, the city staff's acts were at least consistent with this contractual dispute resolution process. And I ask your honors to consider the Valero versus Department of Revenue case. In that case, the Arizona Department of Revenue, an actual tax examiner who was authorized to say these things, said to the taxpayer plaintiff, you don't owe tax for this particular freight. Relying on that, they didn't pay tax. Then they got a deficiency letter and were owed the tax. Even in those facts, the Arizona Supreme Court said, well, we're not sure that rises to the level of estoppel. When something is absolutely wrong, nothing the city of Sedona said was wrong. We got your claim. There's a contract process. They're evaluating it. That's what they did. That's what they were supposed to do.
Counsel, when did you ask for attorney's fees?
We asked for attorney's fees in our reply to the motion to dismiss, Your Honor.
And not in your motion?
We did not ask for it in the motion.
Okay.
I'll address that real quickly. We believe that Ballesteri and King versus Titworth say it has to be raised in the pleadings, the motions themselves, and not the opening motion. I don't really have much to add to what we put into the brief, subject to your questions, but I'll rely on that in the brief. Okay. Thank you very much, Your Honors.
Thank you. Counsel?
Your Honors, I'd like to go through a few things that were addressed in SEDONA's argument. First of all, Judge Winthrop, in response to your question, I checked our brief, and we're not disputing the January 2014 accrual date. I'd like to address the fact that there was no request for leave to amend. This is not a case where we have a failure of a court to make a ruling. The judge in this case, at the same time as he granted the motion to dismiss, immediately entered judgment. And in that same minute entry, that same signed judgment, denying or granting the motion to dismiss, addressed the possibility of amendment, rejected amendment, and explained his bases for doing so. So at that point, it would have been a waste of time to do any kind of post-judgment motion because the judge had already addressed the issue, raised the issue on his own, and made a ruling, including reasons that this court can evaluate. In the Blumenthal case that Sedona raised, there this court emphasized that there was a 3-month delay between the grant of the motion to dismiss and entry of final judgment. During that 3 months, the party could have but did not file a request for a motion or file a motion for leave to amend. But here again, we have the very unusual procedural quirk that the judge entered final judgment in one fell swoop in the same order in which he granted the motion to dismiss. So there was no opportunity to request leave to amend other than in some kind of a post-judgment motion, but that would have been a waste of time and unnecessary because the judge had already explained his reasonings. Sedona also mentioned the fact that we had already amended once and mentioned that the motion to dismiss. The first motion to dismiss raised statute of limitations issues, which are now have fallen away, and notice of claim issues. But at that point, because the notice of claim was not in the record at that point, there was no dispute about which party or which person at the city the notice of claim was served on. So because that had not been raised, there was no obligation in the first amended complaint to affirmatively and preemptively rebut the notice of claim issues about service. At that point, nobody had put Yellow Jacket on notice that the wrong entity had been served. And again, we do not dispute that the wrong person was served. This is not a case about substantial compliance. It's not a case about whether we fulfilled all of the purposes behind the notice of claim statute. All of that we can set aside because Sedona does not dispute that despite that area of the law, waiver and estoppel still apply to this area. They're still valid, equitable doctrines that apply to rebut the affirmative defense of notice of claim. I think about whether this was a notice of claim under the statute, notwithstanding the improper service, this was absolutely a notice of claim under the statute, not under the contract process. There was a shift in the parties' communications and behavior in October 2013. Before that, the notices that Sedona or that Yellow Jacket served followed the contract process. They had the right title on the top. It was notice of potential claim. That's exactly what the contract requires. There were change orders. If you look at appendix pages 98 and 99, you'll see the timeline there. There were notices of potential claim, there were change orders, and then that bubbled up in October 2013 to a notice of claim. The title on the document changed, and Sedona's behavior changed as well. That's when outside counsel was engaged, and so on. And if you look at those pages 98 and 99, you'll see that there were ongoing parallel processes. There were further change orders, and there were further notices of potential claim, but there was absolutely a firm notice of claims dated October 24th, 2013, and that's when everything changed. Now, Sedona mentioned the fact that there was no active litigation in this case. And we agree that the typical waiver and estoppel cases in this area arise most frequently in litigation, where a party is involved in litigation, fails to assert the defense. That's the most common fact pattern, but it's certainly not the only possibility. That's the most common pattern when you have waiver or estoppel through inaction. But here we have waiver and estoppel through action. And there are multiple cases on this. Of course, we focused on the Young case in Arizona, on the Teresta case in New York. There continue to be cases in this area. After the briefing was done, a new case came out in New York. This is Connor v. New York City Transit Authority, Connor with a K, Konner. It's at 143 AD 3rd 774. This case came out very recently after the briefing was complete. There, the plaintiff sued the New York City Transit Authority for a claim about an injury in a subway accident. The claimant sent the notice of claim to the MTA, which is the Metropolitan Transit Authority. The MTA and the New York City Transit Authority are different, but the notice of claim made its way to the correct entity, to the New York City Transit Authority. The New York City Transit Authority, the correct entity, responded to the notice of claim, requested an appearance and testimony from the claimant. The court said because of that, and despite it specifically addressed the reluctance to apply estoppel against government entities, but it specifically said, nevertheless, regardless of that reluctance, under the circumstances of this case, the plaintiff's submissions demonstrated that the New York City Transit Authority wrongly or negligently engaged in conduct that misled the plaintiff to justifiably believe that service of the notice of claim upon the MTA was of no consequence, and lulled her into sleeping on her rights to her detriment. Accordingly, the New York City Transit Authority is equitably estopped from asserting the plaintiff's failure to serve a notice of claim as a defense. So we have yet another case to add to the list where you have a government entity that is responding and engaging with the claimant, and as a result cannot raise the notice of claim defense because of the communications to the claimant in which the government entity committed to resolving the claim and working with the claimant without ever raising the notice of claim defense. Sedona also raised the issue in its argument about whether you can waive or be estopped from the defense by conduct before the notice of claim defense became available. And of course you can. Just like, as we said in our briefs, a creditor can waive a debt before the debt ever becomes due. Right? The issue is, has the government entity lulled the claimant into sleeping on his or her rights to her detriment? And that's what happened in this case. The engagement of outside counsel and the letters and communications show that Sedona was treating this as a valid notice of claim without ever raising the issue. That can give rise to estoppel. But again, we're here on whether the court should have granted leave to amend. These facts are facts that we can plead in an amended complaint. If there are issues about intent under waiver or whether we can meet the burden to show estoppel, those are things that we should have the opportunity to plead in an amended complaint. These are not things that ever needed to be in the complaint in the first place, because a party does not have an obligation to anticipate and preemptively plead facts sufficient to rebut an affirmative defense. That's not the law. But because the Superior Court raised that requirement and said that we had to plead facts to preemptively rebut the affirmative defense of notice of claim, then the court needed to provide Yellow Jacket with an opportunity to put those facts in a complaint. And at that point, they can be tested through a motion to dismiss or through summary judgment. That's when they get tested. They don't get tested at this stage when we had no obligation to put them in the complaint in the first place. The court has no further questions.
No.
Thank you.
Counsel. We'll take this matter under advisement and issue a decision in due course. Thank you. We stand adjourned.